Supreme Court allowed the appeal in the matter of REKHA Sharad USHIR versus SAPTASHRUNGI MAHILA NAGARI SAHKARI PATSANSTA Limited and set aside the order of High Court and complaint in Court of Learned Judicial Magistrate First Class at Kalma and the order of cognizance dated 2nd March 2017. While filing a complaint under Section 200 of CRPC and recording his statement on oath in support of complaint as the complainant suppresses material facts and documents, he cannot be allowed to set criminal law in motion based on the complaint, said the court. Setting criminal law in motion by suppressing material facts and documents is nothing but an abuse of the process of law. It was alleged by the respondent that appellant had obtained a loan of rupees 3,50,000 from respondent on 3rd July 2006 through overdraft facility. At time of obtaining loan, she issued two security checks and due to default in repayment, respondent deposited first check drawn on 10th February 2017 for amount of rupees 3,75,976 which was dishonored. Following a legal demand notice from respondent's advocate, respondent filed criminal case under Section 138 of Negotiable Instruments Act on 4th April 2007. Appellant paid the check amount before JMFC Kalwa Court on 23rd September 2016, following which respondent withdrew prosecution and appellant was acquitted on the same date. Learned counsel appearing for appellant submitted that she had already paid first loan of 3,88,077 on 30 March 2007 and said loan account was subsequently closed. Yet the respondent chose to prosecute her wrongly and was forced to repay the entire loan as she did not have the loan statement then and could not prove her earlier payment. It was further contended that a respondent, despite having full knowledge of repayment, maliciously misused the second security check to initiate false proceedings by depositing said check within 10 days after appellant had paid entire amount pertaining to first loan. Learned counsel emphasized that such an act amounted to clear abuse of the process of law. Learned counsel pointed out that while filing the complaint, respondent suppressed most material letters dated 28 November 2016 and 13 December 2016 addressed by advocate for the appellant to the advocate for the respondent, and fact that copies of documents were demanded by appellant were not furnished by respondent. Therefore, complaint is an abuse of the process of law. Supreme Court said that a court of the judicial magistrate can take cognizance of offence punishable under Section 138 of Negotiable Instruments Act based on a complaint filed under Section 200 of Criminal Procedure Code 1973. The corresponding provision under Bharatiya Nagrik Suraksha Sanhita 2023 is Section 223. After a complaint is filed under Section 200 of CRPC, learned magistrate is duty bound to examine the complaint on oath and witnesses, if any, present and reduce substance of such examination into writing. What is reduced into writing is required to be signed by complainant and witnesses. This was a case where very material documents in form of two letters addressed by appellant were suppressed in the complaint and statement on oath under Section 200. In statement on oath, respondent complainant vaguely referred to a false notice reply, but a copy of reply was not produced by respondent along with complaint. Learned magistrate is duty bound to put such questions to the complainant to elicit the truth. Examination is necessary to enable the court to satisfy itself whether there are sufficient grounds to proceed against the accused. After considering the complaint, documents produced along with complaint and statements of the complainant and witnesses, if any, the learned magistrate has to apply his mind to ascertain whether there is sufficient ground for proceeding against the accused. If he is satisfied that there is sufficient ground to proceed against the accused, the learned magistrate has to issue process in terms of subsection 1 of Section 204 of CRPC. Corresponding provision under BNSS is Section 227. Setting criminal law in motion is a serious matter. The accused faces serious consequences in the sense that he has to defend himself in the trial. It is settled law that a litigant who, while filing proceedings in court, suppresses material facts or makes false statement cannot seek justice from the court. The facts suppressed must be material and relevant to controversy, which may have bearing on decision making. Cases of those litigants who have no regard for truth and those who indulge in suppressing material facts need to be thrown out of the court. If these two letters were disclosed in complaint, learned magistrate, while recording statement under 200 section of CRPC, could have always questioned the respondent on supply of documents to appellant. What is important is that in the reply dated 28 November 2016, appellant had reserved her right to give a reply to demand notice after receiving documents. It was respondent's duty to supply documents to appellant or her advocate to enable appellant to properly reply to demand notice. At least inspection of documents could have been provided to appellant. After noticing the fact that notwithstanding service of two letters written by appellant relied upon documents were not provided to appellant, learned magistrate could have dismissed the complaint by exercising power under section 203 of CRPC, as appellant could not have replied to statutory notice without looking as the documents relied upon.